Okay, good afternoon and welcome. We're so excited that you can join us for today's conversation about 5 words that changed America, Miranda versus Arizona, and the right to remain silent. My name is Elizabeth Kronk Warner, and I have the privilege and honor of being the dean at the S.J. Quinney College of Law. And I'm really excited to be introducing and moderating today's discussion with 2 of my colleagues. My pronouns are she and hers. And as I like to do anytime we gather to have a conversation, I want to start off by acknowledging that at least the land where I'm on today, which is in the Salt Lake Valley, is traditionally Indigenous land. And we here at the University of Utah acknowledge that this land, which is named for the Ute tribe and is the traditional and ancestral homeland of the Shoshone, Paiute, Goshu, and Ute tribes, the University of Utah recognizes and respects the enduring relationship that exists between many Indigenous peoples in their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. So it seems particularly appropriate that we should be gathered here today for this really exciting outreach activity to learn more about this great book. So I had the pleasure of reviewing the book, and I thought that Dane Nolan, who wrote a review of the book in the Utah Journal of Criminal Law, really had a nice way of summarizing just how wonderful a book it is and how impactful of a book it is. And I'll also point out that very timely book as well, especially as we find ourselves today thinking about police reform and justice reform, waiting for a verdict in the Derek Chauvin trial, who's accused of murdering George Floyd. So these conversations about police reform and how police potentially might do better, as is highlighted in the book, is really a timely conversation. So Dane Nolan, in his review, explained that Professors Heine and Giora, in 234 pages, so very accessible, it can be read relatively quickly, using original research and the historical record, take us on a journey through the crimes and subsequent legal proceedings that resulted in perhaps the most noteworthy and significant U.S. Supreme Court criminal decision in the past 60 years. The cliffhanger style narrative is propulsive and easy to read. Heine's mastery of legal writing is palpable. The book is about people, and I think we're going to learn a little bit more about these characters and people through their presentation. We get to meet the victims, the family members, the police officers, the prosecutors, defense attorneys, judges, law clerks, and Supreme Court justices, real people making actual history. Professors Heine and Giora have captured from many perspectives what handling a criminal case is actually like for lawyers. The drudgery of hard and meticulous work, the having to take facts as they come, the crafting of an overall strategy, the creative art of presenting a case to a jury, the unforgiving need to preserve every issue for appeal, the vagaries of relying on human people who forget and make mistakes, or who don't want to be helpful or even involved, and the terrors that result from case outcomes, which are never certain and are always very difficult to predict. Lawyers will enjoy the big picture. We get to meet some of the greats: John Marshall, Earl Warren, Hugo Black, Tom Clark, and we get to see the law develop and sometimes regress over time as policies and agendas and interests tug and pull in many different directions. And again, I think that quote right there so captures where we currently are in the United States and makes this discussion so timely. How is the law developing? How is it perhaps moving forward, potentially regressing? What are the politics? What are the agendas? What are the interests that are tugging back and forth? And so I'm really excited to hear today's presentation. So my colleague colleagues are going to speak for about 30 to 40 minutes about the book and give you some background information related to it. And then we're going to open it up for question and answers after they are done. So if you go to the bottom of your screen, you will see, or excuse me, since we're using YouTube, you can submit your comments via YouTube and then those will be sent directly to us. You don't need to wait until the end of their presentations. You can send the questions at any time. And after they're done with their presentations, I'll jump back on to moderate those questions. So without any further ado, I would like to introduce my colleagues. So first, who's going to be speaking first is Professor Amos Guerra. Professor Guerra is a professor of law at the S.J. Quinney College of Law, the University of Utah. In addition, he is also a distinguished fellow at the Consortium for Research and Study of Holocaust and the Law at Chicago-Kent College of Law, and a distinguished fellow, counselor, International Center for Conflict Resolution at the Katz School of Business at the University of Pittsburgh. Professor Guerra is the inaugural chair of the University of Utah Independent Review Committee, which was a presidential appointment from President Watkins. And he has published extensively both in the US and Europe on issues related to national security, limits of interrogation, religion and terrorism, the limits of power, multiculturalism, human rights, and he is the author of several books, including co-authoring today's book that we're discussing. He served for 19 years in the Israel Defense Forces as a lieutenant colonel, and he is now retired, and held a number of senior command positions, including legal advisor to the Gaza Strip and commander of the IDF School of Military Law. He has received grants from both the Stewart Family Foundation and the Earhart Foundation, and was awarded a senior specialist Fulbright Fellowship for the Netherlands in 2008. In 2011, he received the Faculty Scholarship Award from our own College of Law. And in 2015, he was elected a member of the Bencher Society at Case Western Reserve University School of Law. Following his presentation, we'll then hear from Professor Louisa Heine. Professor Heine is a professor also at the S.J. Quinney College of Law. I'm so fortunate I get to work with both of them. And she teaches evidence, legal writing, and judicial process. She also teaches and assists in our academic support program, and she proved instrumental in efforts this past summer to get approval for the diploma privilege licensing during the COVID pandemic. She received the Peter J. Billings Excellence in Teaching Award in 2015 and 2019, as well as the Outstanding Faculty Award in 2016, 2017, and 2019. She is the author of the textbook Judicial Process, Cases and Materials, as well as co-author of today's book. Prior to teaching at the University of Utah, Professor Heine was a professor of legal writing at the University of Colorado Law School from 2003 to 2009. While at CU, she taught legal writing, appellate advocacy, trial advocacy, criminal procedure, and criminal law. In her first year, the students there named her the outstanding new faculty member. She studied law at the University of Colorado School of Law, where she was an associate editor for the UC Law Review, and she was also a teaching fellow. After graduating as salutatorian and Order of the Coif, she clerked for Chief Judge Louis T. Babcock of the United States District Court for the District of Colorado and practiced as a deputy district attorney in Denver in the district attorney's office. So with that, again, it's my pleasure to be here with two amazing colleagues, and I'm going to pass it over to Professor Guerra to start us off.
Thank you, Dean, for that very gracious introduction. It's a pleasure to have the opportunity to speak about the book that Professor Heine and I co-wrote. From my perspective, what's important to share with all of you is the following. We undertook to tell a story about the case. And in order to tell a story about the case, we sought to do what others had previously not done, which was really to engage with the actors who were part and parcel of the story of the Miranda case. And we, in many ways, played the role of, if you will, of detective. We met with people who had been deeply involved in the 1960s in the case. We interacted with them, and we really ended up writing, if you will, a storybook, quote unquote storybook, that makes the effort to tell the story from the participants, from the perspective of the participants. The Dean's very gracious introduction, the reading of that wonderful review, which came out the other day, in many ways captures the essence of the book, because I think I speak for both Professor Heine and myself. The idea was to make this accessible. This was different from a traditional law review article. It's not written as a law review article, with all due respect to law review articles, but it's written in a way that intends, and I think it was Heine who came up with this, make it accessible to our respective moms, that they and their friends could read this and could understand what really is complex legal issues, but to understand it from the perspective of the actors, the participants. To do so, we spent time in Phoenix, Arizona. We need to give a shout out to all those who very graciously agreed to meet with us, to be interviewed by us, because it was important for us in telling the story to do the following. And Professor Heine will talk about this at length. We did not rely on previous works, but we actually put on our Woodward and Bernstein hat, and we did first person research. And in making that decision, again, differentiating from everything else that had been written beforehand, we really met with people directly, and we gathered stories. And in that sense, what the book seeks to do is to tell the story behind the story. And for instance, as an example, we met with the detective who interrogated Miranda that day, Carol Cooley, and Detective Cooley, a gentleman in his 80s today in Phoenix, was beyond gracious with his time. And the fact that we were able to meet with Mr. Cooley and his wife in their home, that he shared with us what it was to be like the young detective who interrogated Miranda, to walk us through that. And we sought to bring the Detective Cooley and others into the book for the reader to hear the story of Miranda through distinct perspectives, through the distinct voices, while, and this is also important, while very much keeping our eye on the legal ball. At the end of the day, both Professor Heine and I, as the Dean notes, teacher at the law school, we undertook to write a book about the law, but perhaps different from other undertakings, to tell it through the lens of stories, through the lens of individuals. So when you undertake a book like this, there's a fair amount of humor because you're meeting with people and people have their stories to share. And as Heine and I learned, people love telling stories. And we spent lots of time with lots of people who tell their stories. And one of the things that we were able to do was, in many ways, to differentiate or discern between what had been assumed to be the facts of the case as compared to what we learned to be the facts of the case. I think that's one of the important takeaways in terms of how to go about doing research in a book like this. You can't rely on what I told Heine last night. You can't rely on Rabbi Google, because what happens with Rabbi Google is everybody refers back to what's already been written. And undertaking a project which is predicated on first-person research, we in essence ignored everything that had been written because we wanted to make sure that we got the facts 100% correct, rather than merely relying on what had been written beforehand. And I think that is an important contribution that the book makes, because it really tells the story of Miranda in many ways that hadn't been told before. And the difference between our book and the previous undertakings with respect to Miranda is it tells a much broader story than the narrow question of the law, which obviously everybody knows about, the Miranda rights, Miranda warnings. I mean, anybody who watches TV, I, for instance, am a total junkie of Law and Order, and everybody who watches Law and Order knows the Miranda warnings. But what this book does is it tells the backstory and works its way to the Miranda case, the trial, and everything that comes thereafter. But in addition to meeting with Detective Cooley and other officials, we also made every effort to reach out to Miranda's family. And I think that makes a significant difference in telling the story, because you want to tell a story from multiple perspectives. It is akin to the Japanese theory of Rashomon. Everybody who's involved has their own perspective. And one of the things that we try to do here was to bring multiple voices to the book in order for the reader to understand it as broadly as possible. We were not, and I think the Professor Heine will agree with me, we're not in any way sympathetic to Miranda, but we bring Miranda to the book. And we bring Miranda to the book in a way that I don't think has been done before, because I think that it is important, if you're going to write a book about a case like this, it's important also to have the perpetrator to be a part of it, because he was, if not for him, this doesn't happen. But we also, if you will, view the undertaking on multiple levels. There's Detective Cooley, who I've mentioned. There are the prosecutors who we met with. There's Miranda, who we tell his story also, but also in terms of the victims. And it's important to remember that Miranda, yes, the Miranda warnings, but at the end of the day, Miranda was a serious criminal. And we also need to, there are those who've, glorified Miranda. That's not what this book is about. In telling the story about Miranda, we also thought it was very important for the reader to come to understand the Miranda's victims, And if you read the book, you will see we really bring the interaction between the perpetrator and the victim to the reader's attention in a very, and this Heine will talk about this at greater length, in a painstaking manner. And I deliberately use the word painstaking because I want to give a very loud shout out and a tip of my hat. I have no hair, but I can give a tip of my hat to Professor Heine, because the painstaking approach, which really is her wonderful contribution to this book, really takes the reader from A to B to C all the way to Z in a way that, again, had not been done before. In terms of the intended audience, I think we went back and forth in terms of intended audience, but when I talk about our respective moms, the idea was really to make this accessible not only to law students and law professors, but also the general public. And as we came to learn, there is so much that had not been told about the book previously, about the case. There had been so much ground to cover that had not been covered. And one of the reasons that it had not been covered, because most people who had written about Miranda focused narrowly on the case itself. And we did something that had really not been done before. And the reason for that is the directive, or the task we were charged with from our publisher, Steve, our wonderful publisher, Steve Eric, because the idea, Steve's publishing house focuses on stories. And so in order to meet Steve's directive and the spirit of his publishing house is to tell stories behind story. And in order to tell the story behind the story, you can't just focus, with all due respect to the law, just on the narrow question of the law, but you really have to dig deep. And in doing so, and I think one of the important contributions from a pedagogical perspective of the book is we were very fortunate to have a wonderful team of students who worked with us. And when I use the word team, I very deliberately use the word team because, yes, Heine and I are the authors of the book, but without those wonderful students who were locked in with us, we met, if I recall correctly, Heine, once a week. We had regular meetings with the students, because what we did here was make a deliberate and conscious choice to have the students working with us. I think from their perspective, it's also important to learn how a book is written, how to research a book. When we went to Phoenix, we took students with us, which enabled the students to also see how one conducts interviews, how one prepares for interviews, how one conducts interviews, how one does the actions learned from interview. And I would think that from a student perspective, the opportunity to work with faculty members who are, writing a book like this, I would like to think that from their perspective was a unique experience, and I think significantly contributed to their law school experience. So now that the book is out, where do we go from here? I think that one of the really important contributions that I would like for the book to make is to cast or shed a different light on Miranda, viewing it, enabling the viewer to, the reader, to view it from a much broader perspective than had been previously understood. I think that's really important. I think we also delve into the history of Phoenix and into what was going on in Arizona at the time. And it's also interesting, there are a number of important cases that have come out of Arizona, including a book that Heine and I are, a new book that we're working on, Arizona versus Youngblood, which, there's an interesting legal history in Arizona, which we had the opportunity to engage with because we met so many people in Arizona. So in terms of where do we go and, next steps from here, one, we obviously would welcome interaction with anybody who reads the book. You always want to know what works and what didn't work, what engaged, what didn't engage. And that's from multiple perspectives. We're very much hopeful that the book will be adopted by faculty around the country who teach criminal procedure, who teach criminal law. But more than that, I really do believe, in terms of a contribution that a book like this makes, is frankly, it examines a case from a perspective that had not been examined before. And that is from the perspective of telling the story from the perspectives of the actors who were directly involved. What we have done in gathering the stories, and then you have to, work the puzzle together, bring their voices loud and clear to the reader in order for the reader to understand the case from its broadest perspective. And so while Miranda has been discussed and written about endlessly, and again, every TV show talks about the Miranda warnings, I genuinely believe that this book really casts the situation, the case, in a totally different light by bringing to the reader the distinct voices. It was, I must say, a wonderful experience to work with Heine. We spent, I mean, who knows how many zillions of hours. And the collaboration obviously worked because here we have a wonderful finished product. We each bring different strengths to a project like this. I think that's one of the reasons that worked really well. Those of you who have co-written, whether articles or books with others, know different people have different strengths. I think in this case, it really merged, it morphed. There was a really effective confluence that enabled us to write this book, to research this book, and at the end of the day, to have it out there. And for me, as someone who, if I may say this, prior to writing this book, I wrote a biography of Earl Warren. So I came to this book, I would never say I'm the #1 Earl Warren fan because there are a lot of people who claim that mantle. But for me, and I'm a person without heroes. Were I to have heroes, Earl Warren would be my hero. And the reason that Earl Warren is my hero is because of the Miranda. And to work on this book and to bring Earl Warren's great case to light, for me was the effective bookend or the right bookend to the first book, which is the biography of Earl Warren. Because Miranda, for me, is the great highlight of Earl Warren, even though when he was asked later in life, was the Miranda the most important opinion you wrote? The answer is no. I respectfully disagree with Earl Warren, but that's okay. But because I came to this book with this, I confess, as a total fanboy of Earl Warren, for me, that was a wonderful opportunity to shine a light on what I think is just an extraordinary decision. But in addition to that, I also, in the first book, but it's relevant to this book, I interviewed Earl Warren's clerks, who gave me great insight into Earl Warren, the person, but also into Earl Warren in the context of Miranda. And so for me, the Warren book and then this book about the Miranda case with Heine really worked for me really well together to shine a light on an extraordinary person, Earl Warren, and a case that has clearly shaped American history, clearly shaped American criminal law history, and absolutely shapes American criminal procedure on a day in, day out basis. And before I turn it over to Professor Heine, I need to refer back to something that the dean mentioned. So here we are, as we all know, whether minutes away, hours away, days away from the verdict in Minneapolis. And I think that whatever each and every one of you thinks of, however the verdict will come out, Earl Warren changed America and changed American criminal procedure. And the case in Minneapolis highlights the powerful tensions that Warren addressed and that we talk about in our book. And in that way, excuse me, the relevance of the book and the relevance of our project gains an ascendancy on a daily basis. And I would think that from the perspective of all of us who are so steeped in the rule of law, in the Constitution and criminal law and criminal procedure, the case in the case of in Minneapolis and the Miranda case and how we have come to the case by telling stories, it becomes particularly relevant in the context of America today. And that I think is highlighted or will be highlighted in the context of the decision in Minneapolis, whatever it will be. Before I turn it over to Professor Heine, I just want to emphasize one more point. In bringing different actors, different voices to the book, we were aware that not everybody may agree with how we presented them. There's always that challenge that when people read about themselves, whether they agree, whether they disagree, that's part and parcel of a project like this. As far as I can tell, and if Heine, if you know different, you'll correct me, but it seems to me that those who we interviewed seem to be very comfortable with how we have addressed, how we have brought them to light. And if we have done so, I think that's an important contribution because it's a great opportunity for people who participated, were involved in making history, that their voices are brought to the table. And if we did that in our book, I think that we owe them a thank you for taking the time to meet with us, because I thought it was really important in doing so, in telling stories behind the stories, which is, again, as I said, exactly the way that Steve Eric, the publisher, wants his books to read. It is telling a story about a case. Louisa?
Thank you, Amos, and thank you to the Dean and the Alumni Association for having us, as well as, I don't want to forget, a shout out to the King's English Bookstore here in Salt Lake City. a small business that has been kind enough to provide a discount code for the book, should you choose to pick one up. So it's a great way to support a small local business. Amos talked a little bit about the painstaking research that was involved, and I think he might have undersold it just a little bit. This was more than 2 years of research, and we really did not take anything that had ever been written before as the truth. So in addition to going to Arizona and doing the interviews that Amos is great at, I spent 4 days in a basement archive in the Arizona archives with 2 research assistants. I also took 2 research assistants to the Library of Congress, and we spent almost a week there. Turns out you don't get to go to the pretty one with the rotunda. You're in the basement one where they have all of the Supreme Court files in manila folders. Not kidding you, manila folders for you to look through. And so then we did dozens of interviews across 3 states, including via Skype. So I think Amos talked about the teamwork that was involved. I think it was a really nice set of skills. I think Amos has undersold his patriotic love for Earl Warren. He said fanboy. I was going to say he has a little crush. There definitely is a connection there with Earl Warren. And because of that, Amos had the knowledge about what was happening at the court, the leadership that Warren was providing on a wide variety of criminal procedure issues in the 1950s and 1960s, as well as just general legal history on criminal procedure. So for example, there's a section in the book where we talk about the Bessemer scandals and the role of Justice Hugo Black in the Bessemer scandals. And that was something that Amos brought. It's something I actually didn't know about, even having taught a different kind of criminal procedure. At the same time, Amos talked about, again, the painstaking nature. I brought, I think, writing skills. That like creative writing degree actually paid off. Mom, paid off. Also, I think more of the archive diver, if we can make that a term. I have the patience to sit there in the basement. And also because I had written that book that the dean mentioned on judicial process with my friend and colleague, Professor Wayne McCormick here at the S.J. Quinney College of Law. I had that historical and procedural perspective on what happens through the court. So it turned out that, as Amos already said, along the way, we found out that a lot of what we believed to be true about Miranda was not true, including some of the facts that had been written by the Supreme Court in the opinion. So it's not a knock on legal researchers to say, well, I cite to him who cited to her who cited to the court, because the court in turn was taking some facts at face value that perhaps it should not have. So my job is to talk to you in our remaining time a little bit about the story here, and hopefully it will pique your interest. So our story starts with a serial sex offender and a detective who was brand spanking new, who had never before investigated a rape case, and in fact had had very little training in much beyond first aid and learning how to shoot at the police academy. And then in the middle of the story, we have 3 truly, truly brilliant attorneys. We have John Flynn, John Frank, and Tony Amsterdam, who many of you have never heard of, but I had never heard of. Hopefully we'll have time to talk about it. We have 3 incredibly brave women, including a teenager who was willing to go, or were willing to tell their stories to the police in some very, I think challenging would be a kind word of putting, their experience, and testifying at trial. And we have some attorneys who were okay, but not great, but who got the job done. And we had 5 Supreme Court justices who really wanted to affect a change. And they realized that criminal suspects historically had been beaten and tortured. And as the court introduced interpretation of the Constitution that put a stop to many of those physical abuses, they saw that police in many circumstances were simply transferring into psychological abuse. And they wanted to change that. And they saw that there was damage in that process that was being done to citizens and the justice system and the goal of solving crime, and that perhaps there was a better way to do it. We have a line in the book, I think it was Amos's, that the case is a way of saying to the police, do better, be better. And I think that that is particularly resonant in the time. And then our story ends with 3 men in a bar and a fight, and a phrase in Spanish that my kids made me practice saying, pásame el cuchillo, which means pass me the knife. So the case does start in the early 1960s with a woman named Barbara, who got into her 1955 Ford sedan in downtown Phoenix, and a young Hispanic man jerked the car door open, pushed her over, threatened her with a knife, threatened to rape her, and ultimately robbed her and left. And a few months later, another woman whose name was Sylvia was leaving her job as a telephone operator, if you remember those days, in downtown Phoenix. And she got in her car, and a young Hispanic man jerked her car door open, threatened her with a knife, and actually she screamed and he left. And she noticed something about the man who had threatened her with the knife. On his right hand, he had a tattoo with the letters E and M. Then a few months later, now we're into 1963, a teenager was leaving her job at a downtown theater. She was a ticket taker, and she was forced into her car at knife point and raped. And she reported that crime. And part of, we hear about the changes in the law in terms of how rape cases are investigated and how rape victims are treated. But this case really is just a terrible story of the prototype of the ways in which rape victims were treated. So she was questioned by a dozen different police officers over multiple days. They questioned her virginity. They asked the doctor at the hospital to determine whether she had been a virgin before she was raped. They purposely trapped her into making conflicting stories. They accused her of lying. They accused her of lying to cover consensual sex. They asked her to take a lie detector test. And when that lie detector test came back inconclusive, they suggested it was because she was either mentally slow or menstruating. And it wasn't until she and her brother-in-law saw a car in the same area that matched the attacker's car and got a partial license plate that the police were able to really get somewhere with the case, begin to believe her. And they followed the trail to a Hispanic man in his early 20s who had been in and out of jail since the 8th grade. So Ernie Miranda, and I'm calling him Ernie, not Ernesto, for a specific reason, because at the time he went by Ernie. Ernesto was an addition that his attorneys added at the Supreme Court level. So Ernie Miranda had served time. This is one of the misconceptions about the case, that Ernie Miranda is a victim in this case, that he was likely innocent. He had served time for burglary, car theft, curfew violations, lack of supervision, window peeping, armed robbery, assault, and attempted rape in a case completely prior to these Phoenix incidents. He had served time in state prison. He had served time in federal prison. He'd been dishonorably discharged from the Army, and in fact had been in Long Ponk Penitentiary, where he lost part of a finger. So the detectives bring Ernie in for questioning. And again, contrary to, I think, what's the common belief, as they were driving Ernie to the station house from his home, he asked them, "Can our conversation be used in court?" And they answered, yes. Accurately, they answered his question, yes. So our detective, Amos mentioned him, Detective Carol Cooley, was the lead detective, this novice, and he and his partner, a man named Bill Young, bring Ernie into the now famous, because of this case, interrogation room number 2, where nothing particularly bad happens. They ask him questions about the little physical evidence that they have, and Ernie just denies everything. And they talk for about an hour, and that's it. And they ask him to do a lineup, and he agrees. And they bring the victims in, and they look at the lineup, and they're unable to conclusively identify Ernesto, or now not quite yet, Ernesto, Ernie Miranda. And so the detectives really don't have a whole lot of anything, and they're brand new, and they don't know what to do. And they did something super smart and super lucky, because when they went back into that interrogation room, Miranda talks first, and he says, "How'd I do?" And Detective Cooley says, "You didn't do so good." And Miranda says, "They identified me then?" And Cooley says, "Yes, they did." And Miranda says, "I guess I better tell you what happened then." And Cooley says, "Yes, I think you better." And Miranda ends up writing a signed confession and tells them everything. But we still don't have an identification from the victims. And so the detectives do something that just seems crazy at this point in time. They run what we call a reverse lineup. So they bring the victims into the room where Ernie Miranda is sitting, and they ask Miranda to identify the victims. And he does that for both Barbara and Patricia. And you can imagine how traumatizing that was to a teenager who had just been raped by this person, to be brought into a small interrogation room and be face to face with this person who begins talking to her. So you'll notice on the booking sheet, which there are lots of pictures in the book as well. Hopefully that's something that helps make it accessible. Ernie Miranda has the letters EM tattooed on his right hand. And did the police beat him? No. Did they keep him for an overly long period of time? No. Did they do any of the things that police officers had been doing up through the 1940s and early 50s? Whipping, hanging, drowning, starving, freezing, burning, sleep deprivation. They did none of those things. They didn't threaten him. They did lie to him about the identification. But even today, police officers are allowed to lie to those who are in custodial interrogation. But at the same time that all of this was happening, Amos's best friend, would-be best friend, Chief Justice Earl Warren, is on the lookout for ways to move this line of cases forward. And so in the middle of the story, I know Dean Cronk-Warner is going to want us to wrap it up a little bit so that we can answer your questions. But we go through talking about what happened at trial. Again, contrary to popular belief, Ernie Miranda actually had a pretty competent defense attorney who preserved the right issue for appeal. He objected on the grounds that Ernie Miranda had not been told he had a right to an attorney at trial. And the kicker is he didn't, not at trial, during interrogation. He didn't. But because Alvin Moore objected on those grounds, it preserved the issue for the Supreme Court to be able to address it. And Alvin Moore was just a civil attorney who believed that members of the bar had an ethical duty to represent people who couldn't afford counsel. So the trial itself is fascinating. Really, Ernie Miranda, on both the robbery and the kidnapping, he gets convicted not because the police did something bad or that they somehow beat a confession out of him, but because these women were willing to testify despite how they had been treated. And because Ernie did confess, and because he testified at trial. And those of you who are defense counsel out there, you should be cringing just a little bit inside, because his testimony was truly cringeworthy. He talked about how he had only stopped to talk to Barbara to ask her for the time. And she lured him into the car and offered to have sex with her. And he was so scared of her and her lustful behavior that he ran away. And it was so bad that Alvin Moore stopped him in the middle of his testimony and said, "I think that's enough," and sat down. So the book continues on talking about the ways in which Earl Warren pulled together 5 justices to come to the conclusion that criminal defendants need to be, or sorry, suspects need to be told certain things to help what the court ends up calling prophylactically protect them and give them information about their rights, and that those rights should apply not just to people who are rich enough and well-educated enough to know that they have the rights, but to everyone, including people like Ernie Miranda, who had an 8th grade education. He was perfectly bright. That's another misconception. His handwriting is quite good. His grammar is good. But he probably did not know that he could, and probably could not have afforded hiring an attorney and bringing that attorney in with him. So we follow the process with these attorneys who take the case on a pro bono basis for free at the Supreme Court. We follow the personalities at the Supreme Court. And then, as you know, the case gets reversed. But Miranda isn't famous because he's special, which he thought. There were actually 4 cases that the court decided to take: Miranda, Stewart, Westover, and Vignera. And as those of you who practice know, when cases are consolidated at the Supreme Court like that, the name that goes first is the first one in alphabetical order. So Miranda is famous because he came in alphabetical order first. You've probably never heard of Stewart or Westover or Vignera. And you probably also haven't heard of what happened after the case was reversed, because the state of Arizona retried Ernie Miranda. And that case, both of those cases on retrial were, I don't know, what's the word, Amos? Like, there are some serious card tricks up sleeves for those 2 retrials. You got a word for that?
Many card tricks.
Many. Did you say many or many?
Many.
There were many card tricks that come out during that retrial. And then we follow the case afterwards. There were a lot of people who were very, very angry about the Miranda opinion and what happened. There were impeachment efforts involving Justice Warren. The court got hate mail. We're here in Utah right now. We have an editorial from the newspaper in Provo about how victims have rights to. There was a lot of backlash about Miranda, which is an opinion that we now take for granted. And then we follow Ernie Miranda through the rest of his life. He wasn't done getting in trouble. So that story is great as well. And for all of this, for example, what happened with Ernie Miranda, we pulled probation and parole reports. We pulled the original police reports from all of this. So I really hope that the reader, not just our moms, by the way, Amos's mom might be there. If Amos's mom is out there, hi, Amos's mom, coming in from Israel. I hope so. Not just our moms, but we hope everyone from law students to maybe even just prospective law students, to lawyers, to the general public who don't know very much about legal procedure or constitutional criminal procedure, will enjoy this because of the human aspect as well as the legal aspect. I think I went over our allotted 40 minutes. Dean Cronk-Warner, I hope you will forgive us and moderate whatever questions might have come in from our audience.
Not at all. What an engaging and exciting presentation. And I didn't realize that Professor Giora's mom was going to be here.
Evidently.
Hello. She's an amazing woman. And someday I want to go to Israel to meet her. So I'm so glad that she is with us today virtually. So we have several questions. One of them is quite lengthy. So I'll go ahead and read the full question, and then Professor Giora and Professor Heine, maybe you can answer the parts that you think are most relevant. So the first question says, in reality, there are significant variations in how the Miranda warnings are given. In your view, is law enforcement obligated to advise, or should it be obligated to advise as part of Miranda, that you can decide at any time to exercise these rights and not answer any questions or make any statements to ask? Do you understand each of these rights as I have explained them to you? And having these rights in mind, do you wish to talk to us now? Or is it enough to advise? You have the right to remain silent. Anything you can and will be used against you in the court of law. You have a right to talk to a lawyer and have present while you're answering questions. If you cannot, yada, yada, yada. So essentially, should we break those up into an understanding of kind of each of the rights, or is it enough that we ask the long statement? Thoughts?
So, Heine, do you want to begin and I'll jump in?
Well, I have a couple of thoughts, but maybe we can tag team a little bit. I'm going to do a law professor thing and kind of answer the question in a backdoor way. You're absolutely right that the case itself doesn't say you have to do any particular phrasing. And so police departments at the beginning really slavishly followed the language directly from the case. And then over time figured out there were some workarounds. One of the justices said at one point, what, are we going to have police cars equipped with public defenders? And really, in reality, district attorneys and police started doing things like a two-step interrogation process where you elicit the statement without the warning, stop, give the warning, and then ask the statements again, understanding that defendants are more likely to repeat the statement at that time. And we have a plurality opinion out of the Supreme Court about whether that's acceptable. So police have found lots of different workarounds. And I think what many police would say at this point is the Miranda warnings have almost become wallpaper. We hear them so much on TV. Everybody knows what they are, but they don't really get, used by defendants in the way that perhaps that they were intended to be used. Okay, Amos, that was a non-answer answer. Take it away.
So I'm going to refer back to the book that I wrote about Earl Warren, because background here is important. And Louisa mentioned that Warren, at the beginning of the 65 term, had given, quote unquote, an order to his clerks, one of whom I interviewed in Los Angeles, Ken Ziffrin. Warren gave the Ziffrin and the other two clerks a directive to find a case that would become Miranda, because he had come to the conclusion, a number of conclusions. One, that police, in his words, not my words, that police were lazy. And that, exactly as Louisa mentioned, that the reality of American interrogation rooms up to Miranda was a particularly unpleasant situation for those who were being interrogated. That's the Wickersham Commission reports from the 1929 that clearly made clear with respect to the third degree, which was the reality of the interrogation room. So Warren, who had been an attorney general and had been a district attorney and was a considered politically conservative Republican, came to the conclusion that enough was enough in terms of what was happening in the interrogation room, which is why he gave an order to Ziffrin and the other two clerks to look for a Miranda case. Warren himself, he is the one who actually writes the Miranda warning. It's actually his words. And it was particularly important for him to be the drafter of that because of his knowledge of what was being done to suspects in interrogation rooms. From his perspective, a clear reading of the warning was absolutely a necessity. I think that as I teach my criminal procedure students, that if Warren knew what was being done through the warnings and how the various Supreme Court holdings have interpreted the Miranda decision and have created exceptions and an exception here and exception there, I think that Earl Warren would be horrified because he was really concerned about the inherent coerciveness of the interrogation setting. And for him, he really thought that the Miranda warning needed to be read in full, to be read clearly. If you're in a careful reading of the opinion, which we discuss obviously in the book, it's not a really jurisprudentially, it's not flowery language that Warren has there. It's almost like a manual to the police, because again, he didn't have a high opinion of them. And I think to the question that it really was important for Warren that it be read in full, read clearly, and be read exactly as he articulated in the opinion.
Very interesting. Okay, the next question asks, overall, what do you both believe was the most fundamental detail that made this case such a landmark in U.S. law?
TV.
Take it, Amos.
TV. I mean, you can't turn on your TV today without the Miranda warnings being read. And I mean, I would imagine, I mean, I don't have kids in the States because my kids live in Israel, but I would imagine a kid, I don't know about it, like Heine's kids, they turn on TV in fourth grade, they already know the Miranda warnings. And I think that, and TV, I don't want to say popularized the Miranda warning, but I think that it really has become an inherent, intrinsic part of American society and American culture. We all know the Miranda warnings. And Louisa is 100% right. Miranda is the beneficiary of the alphabet game, right? Because if his last name was something different, it wouldn't be called the Miranda warning. But it really has become, I genuinely believe this, an integral part of American culture, whatever one may think of law enforcement, whatever one may think of interrogations. The Miranda warnings are just, it's, I don't want to say as American as apple pie, but it really has become a part and parcel of American culture.
And interestingly, while we're talking about misconceptions, that use of the Miranda warning in Amos's favorite Law and Order movies and TV is used improperly, because it gives Americans the false impression that you are Mirandized when you are arrested, and you are not. The case and follow-up cases make clear you're entitled to a Miranda warning. The lawyers out there know this, but you're entitled to a Miranda warning at custodial interrogation, which means you are not free to leave and we're asking you questions. The other, I think, misconception that happens after Miranda is that if you ask for an attorney after being Mirandized, that we bring you one. We don't, or at least we don't have to. Most jurisdictions will just stop the question at that time. So it's not that you have a right to have an attorney brought in. It's a right that you cannot be custodially interrogated without an attorney if you request one. So additional misconceptions there.
And the Supreme Court has addressed this in a number of holdings, like Innis, where there's the indirect interrogation in the car. Where Professor Heine and I think we probably a little bit disagree, is I come from the Earl Warren school that says when you're arrested. But I know that we disagree on that one, and there's obviously discussion on that, and we've discussed that at length. That's a great question.
At some point, you're going to have to explain this obsession with Earl Warren. But so we have another question. So did Detective Cooley express regret about his extended questioning leading to the confession being thrown out and eventually the Miranda warning?
So Heine, I leave to you to answer on Carol's behalf.
Yeah, that's right. So a couple of things. So first, this is a misconception. It was not an extended questioning. Prior to the lineup, it was about an hour. After the lineup, it was about an hour. So I think we get the sense it was extended because that idea seems to undergird the Miranda opinion. But actually, Earl Warren was specifically looking for cases where there had not been physical or psychological abuse. He was looking for a way to extend this doctrine to the every person, regardless. And if he had chosen cases or convinced the court as a whole to choose cases where there had been extended and possibly psychologically abusive questioning, then it doesn't apply to facts like the everyman. So he really wanted it to apply widely. In terms of Detective Cooley, there's two interesting things. First is he thinks the Supreme Court got the facts wrong. And I tend to agree with him. The Supreme Court followed John Frank, who was the appellate attorney for Miranda, one of them, followed his facts. Cooley said to me, and this is in the book, we had a righteous case. And he followed the rules as they existed at the time. What's also and he's still angry at Franks about those facts because he feels like they got twisted. What is very interesting is I asked him, do you think that the Miranda warnings should be overturned? Do you think we should get rid of them? And he immediately answered, no. And I said, why? And he said, because it's the law. He very much believes in the rule of law. But he also still carries Frank's brief around with him, a clipping of it. And he calls it the little brief because he thinks that it's so, he called the facts in it a scandalous lie. He really thinks that they misconstrued what he did. Amos, you want to add anything to that?
I think exactly right. We spent time with Carol. He was very gracious.
He was incredibly gracious before and after the book came out as well.
Absolutely. And we were speaking, frankly, again, what I mentioned earlier, when you interview people for a book like this, and then they read about themselves, you never know how people are going to react. There's a little bit of a risk in that. And I want to emphasize that, and Louisa is 100% right. Carol was incredibly gracious throughout. And when we went to his home with Mrs. Cooley, I I mean, he really was gracious. And I think that, I mean, Louisa is 100% right. Carroll's not angry at the Supreme Court. He thinks Frank's duped the Supreme Court and in terms of how he presented the facts. And so I'm not good at math. Is it 55 years later, 56 years later? Yeah, Carroll's not angry at the court. He thinks that simply that the court didn't know the facts because Frank's misarticulated or mispresented the facts. But in spite of that, Louisa's 100% right. Carroll says the law is the law. And that needs to be respected. But it was really, really interesting. I'm delighted and honored that he spent time with us. You know, this is 50 years ago. And I think, if I may just say one other thing, I think one of the reasons that people were willing to meet with us and to be interviewed by us and to talk with us, for many people, this was, and I say this respectfully, because of the age factor, this was for many people the last opportunity to present their Rashomon, their side of this case, which has really become part of American culture. And I think that we caught people at the right time. I think for some people it was, challenging to meet with us because, age is age. But I really do believe that for many of these people with whom we spent so much time and who we interviewed, that this really was an opportunity for them to tell their side of an incredibly important slice of American history, which goes back to what I said earlier in terms of why our book is so unique and so different. So we actually relied on our own interviewing. We didn't rely on what others had written about others, whether or not they had met them is a different question. We'll leave that aside. But that's the whole beauty of first person or first original research, which is exactly what we did in this case, in this book.
I would add two other things. When we think about misconceptions about the case, remember there were 4 cases here. They all went back for retrial without use of the confession. So as those of you who practice know, we apply this exclusionary rule in essence, and we say if the evidence was gathered in an unconstitutional manner, we cannot use it at trial. All of them either pled guilty or were found guilty eventually without the use of the confessions, which goes to what Earl Warren was aiming for in choosing these cases. The other thing I will say is we didn't take anybody's word for it. So I don't want you to think that because Detective Cooley told me it was a righteous case, I wrote that down and called it good. So for example, Miranda gave some interviews after all of this happened, in really what I view as an attempt to rehabilitate his image. And it was effective in many ways. And he talked about his view of what happened at the early hearings, the bond hearing, the preliminary hearing. And we went back and pulled the transcripts or the dockets and the records and the orders from those hearings in order to fact check what had happened in those interviews. So I don't want you to think that we just said, police said so, we believe them. We really did go back to all of the primary materials to make those.
Hang on,
when we could not make the call, there's an issue at the Supreme Court. We couldn't make that call. And we said, this clerk says this clerk says that, and here's the primary materials that support each version of that. Okay, go ahead, Heine.
So that's a perfect lead in. We need to mention Barry Silverman.
Yes.
There's a wonderful judge on senior status in Arizona who wrote a biography of Miranda, which has never been published. And we're allowed to talk because we've mentioned this to Barry. Barry has the manuscript in his house. And I spent time with Judge Silverman and Mrs. Silverman at their home, making every effort, right, Louisa, to try to get the manuscript from Barry. And try as I might, Barry did not give it to us, but it was wonderful for us to meet with somebody who actually had, spent time with Miranda, wrote Miranda's unpublished biography, and trust us, we try to make every effort to get the manuscript. Louisa mentions a wonderful story about 2 clerks. I met with Clerk A, who told me a particular story, and then I met with Clerk B, who's the person who was the critical actor in the role in the story. Clerk B says that conversation didn't happen. Clerk A says it absolutely happened, and he says, but we were standing here, and the guy says never happened. And in that case, we simply made the decision, exactly as Louisa says, to leave it to the reader. We have to present both sides, and that exactly is the benefit of original research, where you don't rely on what others have written before you, but you go and meet with the source. If the book makes that contribution, I think it's really important to bring the different perspectives to the reader.
Okay, well, we have 2 minutes left. So I want a really short answer to this question, which is we've talked about the influence that the case has had in movies and TV, perhaps wrongfully portrayed. But any thoughts on the international influence of the case? 1 minute each.
So yes, I'll begin.
Because, go ahead. You can take it.
All right, I'll just be really quick. I mean, Law and Order, right? My favorite TV show is like hugely popular around the world. And there's no doubt that one of the contributions of shows like Law and Order and others, it absolutely has brought Miranda to living rooms throughout the world. I don't think there's any doubt about that. And I think it's probably the most known, best known case, American case worldwide. I don't think there's any doubt about that. Louisa?
So I'm going to say we shouldn't be quite so American centric. The court was actually looking at procedure in other, particularly common law countries, to determine if there were other police procedures in the 1960s that did a better job of creating an even playing field without hurting the ability to solve crimes, and came to the conclusion that, yes, it could be done better. Great question. I was watching Unforgotten from Masterpiece Theater the other day, because I'm exactly that geeky, and watching British interrogation, where there is a defense attorney present and their rate of false confessions is lower than ours without significantly hurting their rate of their ability to solve crime. So I think there are even perhaps some lessons that we should continue to learn from other countries.
Perfect. Some food to thought to leave with. So unfortunately, we're at the end of our time. It's 1 o'clock. A big thank you again to Professor Giora and Professor Heine. Your book is amazing. It's such a joy, and it's so gripping to hear the story and all of your excellent research. Thank you for sharing with us today. And again, a big hello to Professor Giora's mother in Israel, and to all the rest of you for joining us. Thank you so much, and we look forward to seeing you again next month for our next Dean's book review. Thank you.